So this is video 3 in a 3-part series where I've been telling the story of course, someone will call Blake, not the client's real name. But in this video, we're going to talk about finally that third piece around intellectual property. And what we did, like first, you're probably going, wait, if you missed the other videos, first, go look at them, right? You can, they're in the playlist. But we got into the intellectual property aspect of her situation she went from a sexual harassment case and discrimination to us talking about intellectual property. And you're probably going, how in the world did that happen? I'm Nancy Schick of 30 Year Conflict Resolution, where we take a holistic approach to even employment law situations. So I'm a mediator, and I have a lot of training to look beyond just the immediate legal issues. So that's how we ended up in this situation. As we're talking through the employment structure that Blake had, we realized she had been misclassified. And as I talked about in the other videos, you might be going, why? Why would she have been misclassified? Usually employers want to have people labeled independent contractors. Why would they make her an employee instead? And it was because of the intellectual property. So why, again, would you even do that for intellectual property? You might remember if you signed an employment agreement that there's a work for hire clause in it. In almost all cases, there's going to be a work for hire clause that says anything you create while you're working there, your employer might claim. Now, it's a lot more complicated than that, and I'll leave that to intellectual property lawyers. But in Blake's case, it was pretty clear that that was what was going on, is they wanted her IP. But she came to this work relationship with that IP. So the first thing that we did is we reclassified her as an independent contractor, which is what she should have been all along. Then we formed an entity to not only hold her intellectual property, but to hold her employment. And then she still went back and worked for what had been her client all along, but we did something even better for her, and we got her a license for that client to use her intellectual property. That's what we do here, is we look for these holistic ways. We look at it from a global perspective and we look at ways to have everybody win. What is it they're looking for? Why are they doing what they're doing? It's not just send that standard contract over and you sign it. All right. So if you're not sure if you have been misclassified, or maybe you're an employer and you're not sure if your workers are, then you can do a few things. One, you can go and click on some of those videos where I talk about worker misclassification in the playlist. Just go to the playlist here on this YouTube channel. You can hit that subscribe button while you're down there, because I continue to talk about this issue a lot. And of course, I'll put a link in the notes to the video if you want to set up a consultation with me. And in the meantime, keep listening with your third ear. For those hurts you can heal.